Okay, this is Dr. Herskowitz, and now we're going to start talking about Chapter 13, which is a quick look at the criminal law, and especially as it affects business. We're not going to go into a great deal of depth on the criminal law because that's a whole different subject in itself. This video will actually be in two parts. The first part's talking generally about criminal law, and the second part will get into specific criminal statutes. Okay, the learning objectives on this is first we want to be able to recognize the basic terms and procedures that are relevant to any criminal conduct. And then we want to talk about the 4th, 5th, and 6th Amendments. Remember, you should have read the Bill of Rights at the beginning of the class, and this section will talk about 3 of those items. Part B will identify the elements of specific crimes, and it's important for you to understand what it means when somebody creates fraud or they embezzle, and what has to be proven in order to convict that person. And finally, we want to understand the far-reaching impact of criminal behavior, as the same acts can give rise to both civil and criminal liability. We'll be talking about double jeopardy. Okay, what are crimes? Crimes are wrongs against the society. Criminal law punishes wrongdoers who affect the ownership of property. And that's personal property, it's physical property, it's intellectual property, and it's the rights that individuals have. Federal and state penal codes define criminal acts and omissions. This is a part of the law that is very much requires a law to be passed by the legislature. Whitewater crime is a term that's used for illegal offense that occurs in business or in a professional setting. And it's committed to harm the business or for personal gain. Many crimes may also be a private tort that allows for private action against the defendant. We're going to be talking about torts in a couple of weeks. Examples of white-collar crime are listed here. You can look at this. It's also in the text. Okay, the classification of a crime. A felony is a level of severity. Less severe crimes are classified as misdemeanors and can result in jail time or of less than 1 year. But the more severe crimes are designated felonies and can result in imprisonment for more than a year in length. And there are often monetary fines along with the criminal judgment. There's a significant difference between grand juries and petite juries. The grand jury determines if there's sufficient evidence to warrant a trial, and a petite jury determines the guilt or innocence. Petite juries are basically the same as juries, as the general terminology. Okay, so you've got a felony, which is an indictment from a grand jury with a year imprisonment or longer. Misdemeanor is information or a government charge, and a fine of less than a year. Okay, basic concepts. Crime. The underlying criminal conduct and a key to successful prosecution of that conduct in court is the existence and ability to prove some level of willful or knowing intent by the perpetrator. They must have acted willfully and knowingly to be guilty of a crime. In legal terms, it's called mens rea. They have to have intended to do the crime to be guilty of the crime. Otherwise, it's a civil action for negligence or some lesser thing. So, criminal action is willful and knowingly participating. Okay, there's 3 possible pleas in a criminal case. There's guilty, there's not guilty, and there's no contest, or nolo contendere, which stands for no contest and allows for sentencing as if there had been a plea of guilty, but without the impact of a guilty plea for subsequent civil actions. If a person says no contest, you cannot use that to prove in another case that they were guilty of that action. You have to prove it from other evidence. Okay, you've all heard about a grand jury. What is a grand jury? Well, the grand jury is set up by the Fifth Amendment of the U.S. Constitution. Before a trial, there must be a presentment or an indictment by a grand jury. This is comprised of 23 citizens, and they determine that there's probable cause for the case to go forward. There's always a presumption of innocence, presuming that an indicted person is innocent until found guilty by a jury. They serve as an investigative body. It's kind of like they're not determining that a person is in fact guilty, but it's an extra protection that U.S. citizens have, that they cannot just be thrown into jail or into a court without a reasonable case before them. And the grand jury is one that determines that there is in fact sufficient evidence to indicate that there is probable cause for a trial. It does not find the person guilty, but it does subject them to a criminal case. Functioning depends upon the secrecy of the proceedings, and therefore everything that the grand jury does is kept totally secret. Crimes punishable by imprisonment for 1 year or more are called, answer the question, 1, 2, 3, okay, felonies, you're correct. Okay, the Bill of Rights. Again, I hope you read that during the first week as it was part of the reading assignment, but the first 10 amendments to the Constitution are referred to as the Bill of Rights. This protects individuals from the power of the government, and it includes persons accused of crimes. The Fourth Amendment of the 10 amendments protects individuals and corporations from unreasonable searches and seizures by the government, by the police. It requires the police to obtain a search warrant if they are going to seek information from somebody's home, their business, or otherwise. There is an expectation of privacy in the U.S. You are entitled and protected to your privacy. And as we'll see from the Fifth Amendment, you're protected from self-incrimination. And so the Fourth Amendment helps on both protecting your privacy and protecting you from self-incrimination. There are warrantless inspections that are allowed. Police or other government officials, such as health officials, can come in and look at commercial premises so long as it's reasonable. That means that the health department can go into restaurants and check them out without a search warrant. If they find a violation of the code, they can then cite that restaurant, that business, those owners. Another warrantless inspection is a search of a person being arrested. If a person is being arrested, the police have the right to search that person, so long as it is a legitimate arrest. The police cannot fabricate an arrest in order to stop and search somebody. Nursing homes consent to warrantless searches as a condition of receiving Medicaid funds. And private residence, it is unconstitutional to have a warrantless inspection of a private residence. One of the interesting cases, it's in the text, is dealing with search warrants, is Riley v. California, a 2014 case. In this case, the police had arrested a person on a moving violation. They got them out. They suspected from evidence that was around him that he was part of the Crips. The police then found a cell phone on him, and they opened up the cell phone, looked at a lot of the information. They took it back to the police station. Another person looked at it in depth with the purpose of trying to find whether or not there were implicating information on that cell phone that would have shown that this person had been involved in other crimes. So while he was stopped for a traffic violation, he was arrested, and the information on his cell phone led to further weapons charges. The plaintiff moved at the beginning of the case to suppress the evidence obtained in his cell phone based on Fourth Amendment right. The trial court denied that motion because it was what they felt was a legitimate search as part of a legitimate arrest. The California Appellate Court confirmed the trial court, and the California Supreme Court upheld the California Appellate Court. It was then appealed to the U.S. Supreme Court. Remember, state cases that go all the way up to the state Supreme Court may be appealed. In a rare unanimous decision, the Supreme Court reversed these decisions and held that the police needed a search warrant to access the cell phone data. It's an interesting little sidebar. Chief Justice Roberts wrote the opinion. It's well worth reading and understanding why they felt that a cell phone was different than a wallet or a purse. This case does not prohibit the police from searching personal cell phones. It merely requires that they get a search warrant before they do so. So there are legal protections for the individual involved. The Fifth Amendment is a protection against self-incrimination. This protects an accused from being compelled to testify against themselves. We've all seen both the newscasts, the movies, where the person refuses to answer the question on the grounds that it may tend to incriminate them. They claim their Fifth Amendment right. The Fifth Amendment does not protect against requiring physical evidence to be produced to a court. Even if that evidence was produced or made by the individual, the physical evidence must be produced. A person who is required to produce business records will have to testify. However, they are not required to answer questions that may incriminate themselves. They have to answer questions about the actions of the corporation, about the actions of the business documents that have been supplied. But if it leads to an incrimination of them personally, they do not have to answer that question. So, tight line, very technical, need a very good lawyer if you ever get in that situation. The Fifth Amendment does not protect corporations. Everything that they have is open to judicial scrutiny. The exception is sole proprietorships, because that business is treated like an individual, and so a sole proprietorship does have the protection of the Fifth Amendment. The concept also in the Fifth Amendment is double jeopardy. Individuals cannot be tried twice for the same crime. However, that does not prevent more than one prosecution for an individual. There are federal laws, that would be one case. There are state laws, that would be another case. And there's civil suits, which are private actions. And a person could be liable for each of these. So it is not double jeopardy if they are dismissed from a state law and the same facts give rise to a federal law, then the Department of Justice, the DOJ, can prosecute them under federal laws. And after the government gets done with an individual, another private party may bring a civil suit and actually use the evidence that had been generated in the criminal action as part of the civil suit. This is also leads to the doctrine of res judicata. This prohibits subsequent civil actions involving the same parties, claims, and causes of action. This is more to judicial, it's not so much double jeopardy as making sure that the courts are just not overburdened with cases going on and on and on. So the doctrine of res judicata says that once a case has been found in a civil case, it's over and cannot be retried. The Sixth Amendment provides multiple protections that offer the right to a speedy and a public trial, trial by jury of one's peers. That has a lot of implication in constitutional law. And remember, a jury trial may be waived by the parties. Sixth Amendment guarantees the person's right to be informed on the charge against them. We take that for granted in the U.S., but there are other places around the world that people are tried in secret and they don't even know what they're being tried for. Also, in the Sixth Amendment says that if a person is being charged with something, they have the right to be confronted. They are allowed to confront the accuser and challenge them on what they've said. You have the right to subpoena witnesses in your favor, and of course the prosecution has the right to subpoena witnesses that would be favorable to them. And